Yes, Mr. Fitzgerald.
My Lord, I appear for you at Layne, together with my learned friend Mr. Timothy Nesbitt of Queen's Counsel and Amanda Clift Matthews, and also appearing is Mr. Ruggles Ferguson, the former president of the Grenada Bar Association and the former president of the OECS Bar Association, and Cajetan Hood, the former Attorney General of Grenada. My Lords, my ladies, we just to check.
Before you embark on your submissions, I understand that you're appearing, as so many times in the past, pro bono, Mr. Fitzgerald. I, for one, consider that it's a largely unsung and neglected commentary that so many distinguished members of the bar appear, particularly in this court, pro bono. And I know that you must be the pro bono king, so to speak. We are very grateful for your appearance and for the submissions that you've made. And I think that the fact that you are appearing without payment of any fees should not go unremarked. Thank you.
I'm very grateful. My Lord, that of course goes for all of
yes,
all
quite.
of art. And indeed, I think that in the Grenadan appearance before the High Court, the appellant was represented by 17 members of the Grenada Bar giving their services for free.
Good.
Can I just indicate this? I'm very grateful, my Lord, but there's a case the court has, and then our reply to the very helpful note provided by Mr. Hayne, and then there is the chronology of the proceedings, which may just be relevant to the question of the new evidence.
Yes. Well, we've read
yes.
all of those submissions and your response to Mr. Haynes.
Yes.
And we're confident that you won't need anything like the indented for time.
Okay. Well, my lords and my ladies, can I just take it? Okay, just as
yes, absolutely.
Just go. Well, if I can just take you to the case just by way of the introduction, and then what I'd propose to do is just shortly the issues, then the facts, which are set out at Part 3 of the case, the judge's judgment, the errors of law that we respectfully identify there, and then to develop the analysis of the law in a little bit more detail. But so just starting, the court has a summary at Part 1 of the issues raised in this case. And of course, Mr. Layne was one of a group of 17 defendants who were convicted by a court in Grenada of murder 35 years ago. And those murders, as the court will know, occurred against the somber background of the Grenada Revolution and the falling out of two factions in that revolution. Mr. Bishop, the Prime Minister, and then the Central Committee of the Revolution, and matters ended in violence and then in the execution by firing squad of 10 members of the government. The original conviction of murder in 1986 were the subject of deep controversy, but in any event, we respectfully submit Mr. Layne, who was originally subject to the death sentence, many of them came within days of being executed, has now served the substituted sentence of 40 years imposed on him in 2007 in full, yes. and been released in expiration of his sentence. The court, I know, has, it's set out at pages 1 to 4, following just the history of Mr. Layne. Just can I briefly summarise in 3 stages? Whilst in prison, he took law degrees at both an LLB and an LLM by external study. He then obtained the legal education certificate at the Hugh Wooding Law School in Trinidad, and was the top student of the whole of the class. And the Grenada Bar Association awarded him the Grenada Bar Association's award for the most outstanding student of that year. And I know that the court has that whilst in prison, he not only studied, but he organised other prisoners in sports, engaged in literacy programs, and was described by the Court of Appeal as having met and surpassed the test for subjective rehabilitation. I can just give you the court those references. Paragraph 43 of the Court of Appeal's judgment at 294 to 295, what they said was he met and surpassed what they described as the subjective test of rehabilitation. And at paragraph 58, they said that there was, at page 301, there was overwhelming evidence of rehabilitation. So that is the background against which we say that the relevant provisions lay down the test of good character as the condition of eligibility, and indeed the judge correctly at the start of her judgment said the sole issue in this case is the issue of good character, the sole issue. So she didn't purport to rely on any discretion to say, well, you're of good character, but she focused on that issue. However, it's our respectful submission that she never made a finding that he was not of good character, and that is important as one of the errors that we identify. And the Court of Appeal, we would say mistakenly, approached it on the basis that it had been an exercise of discretion, whereas in fact we say it was if it was anything, it was a finding on the issue: is he a man of good character?
A matter of judgment.
It's a matter of judgment, but not of discretion.
Yes.
But your predecessor, appearing in the Court of Appeal, put the case in terms of her having exercised a discretion, didn't he?
Yeah, my Lord, Mr. Ferguson's here, and obviously is a co-signatory of all our pleadings. He accepts, it was first formulated actually by the Attorney General as a matter of discretion, and he adopted that. But my Lords, my Lady, we respectfully submit that if there's an error of law, of course it doesn't help if counsel go along with it, but it is an error of law, and we accept that matters did get.
Yes.
Well, we respectfully submit matters got confused.
Would you agree that it is properly to be described as an evaluative exercise?
Yes. It's a judgment. My Lords, my Ladies, in due course, I will hopefully show you both the American cases, and we've actually discovered some South African cases which focus on the issue of moral character. Is this person a person of good moral character? We accept it's a judgment, but we say that judgment must be made. It can't be ducked. You can't, just as it were, tail off into, in the light of all this, I refuse your admission. You actually have to say, I find that you are not a person, or you haven't established you are a person of good moral character.
But so ultimately it's a question of fact. An evaluation may lead to the conclusion of the court on it, but it is a question of fact.
My Lord, I think I do accept that, and then and the American cases are very helpful in this, because what they say is that the test that must be applied is this person a person of good moral character now, present good moral character? And again, the South African cases, which I hope I can show you, say the test is a test of present character. Now, so it's an assessment, is this person a person of good character? But we do respectfully submit that in the end that issue has to be confronted. And in all the clearest cases, the issue in a situation like ours is formulated quite simply as, has this person shown that they are so far rehabilitated that they can now be described as a person of good moral character? That's the test. And as the court knows, we into that, the rationale of saying you must be fully rehabilitated is why, in order to maintain the reputation of the profession. But we respectfully submit that there is no room for, we accept you're fully rehabilitated and a person of good moral character. However, the public may react to this badly, so we're not admitting you on some other test. And the statute in this context is very clear. Is the person of good character? So that's the essence of our case. We have, I will analyse, would the court just permit me to just very shortly highlight certain points in the factual background first?
Yes, well, on the basis that we are fully familiar with it, so you can take it very shortly.
All right, well, the conviction is set out at 3.2. We accept that the conviction was on the basis that the committee had issued an order to retake the fort and liquidate them. It was just liquidate them. Yeah. And that the evidence of the chief prosecution witness, Cletus St. Paul, was that he'd heard a conversation where he didn't actually hear, he saw them having a conversation, then he heard a person called Layne Cornwall say to the soldiers, retake the fort and liquidate them, and everybody shouted orders of the committee. So he was the bodyguard of Bishop, so he wasn't an unbiased witness, but that was the evidence on which they were convicted. So we've set that out at 3.2. The conviction, the history of the conviction, we've set out at 3.3. The deficiencies in the process. It's not meant to be disrespectful of either Sir Dennis Byron, a most distinguished judge, or the Court of Appeal, but it is a fact that the jury panel was selected by a court registrar who'd been a member of the prosecution team. The in-panel members of the jury expressed open hostility and expressly said, "You killed Morris, we're going to kill you." Yeah. The trial process led to the trial lawyers withdrawing, and perhaps most important is there is evidence before the court, particularly in the evidence which was sought to be adduced in the Court of Appeal, that there is within the community in Grenada knowledge of the fact that there are real questions over the due process of this process. Can I just give you the reference?
I mean, your printed case accepts that you cannot go behind the conviction.
No.
So what is the purpose of the submission that you're making now?
My Lord, it simply goes to this, that if one's asking the question of the reputation in the public, the fact that there are questions, that the public perceives this as a questionable conviction is in our...
The test can't possibly be whether the public would regard him as a man of good character.
Well,
this is a decision that is for the court.
Well, my Lord, I accept that. I accept that at the end of the day. But to the extent that there's talk about this would damage the reputation of the profession in the views of the public, we respectfully submit that
that's not an issue that's decided on a case-by-case basis. This murder would damage the reputation of the bar in the eyes of the public. That murder wouldn't. The question we're really concerned with, surely, is whether this kind of offence, if committed by a member of the bar,
well, I would respectfully submit not. And my Lord, it may matter. It may be relevant what type of offence it is, what the context is of the offence. And certainly in the South African cases, they've drawn a distinction between what they call political offences or offences in the time of war. There's a famous case of Kraus, where, going back to the Boer War, where they said because of the nature of the offence, it didn't reflect on the inherent moral bad character of the individual. And so we do respectfully submit that the context is relevant and the understood context. My Lord,
Mr. Fitzgerald, you've adverted to concerns about the original trial. Yes. You've adverted to concerns about the Court of Appeal dismissal of the appeal. You haven't, and I don't think you can, criticise the disposal of Mr. Justice Bell, before whom you appeared. No, and his decision was that the right sentence for your client was 40 years.
Yes.
Now, shouldn't we, as it were, take that?
Yes, my Lord.
And take that as an indication of the extreme seriousness of the offence.
My Lord, I accept that. I accept that. Well, the court has set out at Part 3 the submissions, and if I can take you to 3.8, we have Justice Bell's statements on reformation. He took, and he says at paragraph 110, Ms. Layne is recognised as the main author of Reflections and Apologies. He has completed the LLB course. He deals with his religious outreach, his key sports organised in the prison, and then he deals with his good works. After the hurricane, the prisoners did not run away but stayed and helped to reconstruct the prison. And then one has the judge recite in her judgment the submission that the evidence of rehabilitation since the offences is overwhelming, and the Court of Appeal, as the court knows, talked about the test being met and surpassed. My lords, can I then turn against that background to the actual judgment of the judge in this case, and if I can take the court to that at I won't. I'll go to the actual grounds afterwards. But if I can just take you to, we've summarised it at part 5, but perhaps we should take it in detail. So part 5 from page 453 onwards. The judgment is set out at page. Page 86 to 87, it starts. Could I just take the court straight away, unless I'm asked to refer to it, that having sections clearly envisages there are 2 limbs to the admission process: 1, the academic and professional education requirement, and 2, the requirement the applicant be of good character. The legislation confers eligibility, but not an entitlement to practice. As the court knows, we take issue with that. But in any event, in this case, the judge did not purport to exercise some general discretion. She posed the question at paragraph 10. Therefore, the sole issue by this court is the applicant of good character?
I didn't actually realise, Mr. Fitzgerald, that if one got to eligibility, you were saying that there was no discretion.
That is
one doesn't get to eligibility here. One's on a threshold point.
That's right.
About good character.
Yes, that's
but
right.
I didn't realise you were disputing that if one did, there would be an element of discretion.
My Lord,
it would have to be a very narrow discretion.
Well, it's very difficult when the statute sets out the things, because the danger is that what's left would be, we don't particularly like you, or there is, or
I understand all
people
that.
don't particularly like
Anyway,
you.
we don't get to eligible.
No. So
it's good character.
Good character.
Yes,
and she says that's the sole issue. Then she deals with good moral character being defined as the aggregate of moral qualities which belong to and distinguish an individual person, which we accept it is about the personal moral qualities of the person. And then at the case of Schwer, which we have if the court wishes to see the US Supreme Court case of Schwer, high sense of honour, granite discretion, strictest observance of fiduciary responsibilities required. That was a case of a person who had been criminally convicted of being a communist in the 30s, and the US Supreme Court interfered with the local courts and said he is a man of good character because of the nature of the conviction. We have it here. And then in the Layne case, which again we have for the court if necessary, there's the reference to the bar, the ordinary profession. But in Layne, perhaps I could hand Layne up to the court because it's cited there. The court says, the court, and this is the only decision we have from the Eastern Caribbean,
Yes?
paragraph 13, one sees that in Layne, Mr. Justice Benjamin adopts at paragraph 13 in the case of Reed Chekwe, the Supreme Court of Zimbabwe, in a judgment delivered by Chief Justice Gubai, spoke of the maintenance of the integrity and honour of the profession. In construing a fit and proper person, he had this to say: fit and proper person allude, in my view, to the personal qualities of an applicant, that he is a person of honesty and reliability. And so that's the important thing, is it is in the end, in our respectful submission, a question, is this person now a person of honesty, integrity, of the necessary moral qualities? And then one sees at paragraph 18, the judge sets out, the test of character is a very high test. It's nothing to do with punishment, reward, or redemption. We agree with that. The test is whether there is a potential risk to the public, or more importantly, there will be damage to the reputation of the profession. My Lord, what we say is the damage to the reputation of the profession is the reason why the test is high, rather than a separate and additional test. That's our submission. And if we then look at paragraph 20, the judge adopts verbatim, effectively, the submissions of the amicus, and one sees that the onus is on the applicant to prove he is of good character, which was one of the threshold requirements. Test of good character is a high test. It's a balance of probabilities. And then good character has a subjective element, i.e. the applicant is a person of integrity, honesty, and reliability. Evidence of past convictions are relevant to the proof of this element. Good character also has an objective element, namely reputation, but the predominant concern is not the reputation of the applicant, but of the profession. Now,
subjective may not be the right word to describe it. It's all objective, isn't it? But one is an objective finding of fact about the personality of the individual, and the other is an objective finding of fact about the criteria by which his position would be considered by the public at large. I mean, there may be a problem about whether the latter is relevant, but the subjective-objective distinction is that these are complete misnomers.
That's our respectful submission, my Lord. We say there's no that there are two we say there's a single objective test, which, as your Lordship says, a question of fact informed by an evaluation. Is this person before me now, 35 years after the offence, a person of good moral character?
It isn't really an error of law, because they simply used the wrong labels to describe what they were doing, but they actually applied an objective approach to both.
Well, my Lord, when one comes to the Court of Appeal saying he's met and surpassed the test for subjective good, we say they're effectively saying we accept he's reformed.
But I mean, that is, leaving aside questions of relevance, that is an objective statement about him. It doesn't seem to me that the court was actually applying a subjective test to anything. It was just using the word subjective in a rather loose, not to say inaccurate way.
And I think they may be able to blame Lord Layne for it in one of the judgments of where the subjective-objective words crept in for the first time. But
well, wherever the blame may lie, it sounds as you're at one with Lord Sumption.
I'm at one with my Lord Sumption, respectfully, that it's an objective test of fact informed by evaluation. Is this person before us a person of present good moral character?
I didn't say present.
No, sorry.
No,
sorry.
But even that leaves the question of interpretation of what, in the context of admission to the bar, constitutes good character, given the wealth of jurisprudence around that subject.
My lady, I accept that. The wealth of jurisprudence says that in deciding how high and exacting the test is, you have regard to the need to maintain the reputation of the bar. We accept that. What we don't accept, respectfully, is that once you've come to the conclusion that this is a person who is, at present, a person of good moral character, that you can go on and say, but in some way it would bring the bar into disrepute if he was called. We say that the only issue is the person of present good moral character.
Right.
But, my lords, my lady, there are other errors we say, but which I probably better turn.
Absolutely.
Yes, but and the fact is that the judge doesn't, in the end, say anything about it. She doesn't make a finding. I mean, and then one sees
she must have thought that he was not a good character, because that's the issue that she defined for herself.
Well,
And she decided it against him. So, I mean, how can one possibly suggest that there was no...
well, my lord, the Court of Appeal did exactly that. The Court of Appeal thought it was an exercise of discretion. And that indicates that it isn't self-evident that she made that finding. On the Court of Appeal's view, there was some sort of overriding discretion that was exercised, which can't be right.
She says at paragraph 10, the sole issue for this court is the applicant of good character.
Yes.
That must be, therefore, what she decided.
Well, my lord, if there weren't all that intervenes, I would respectfully accept, but can I just take the court and try to persuade your lordship to the contrary?
Right.
One sees that then I take note of the observations of the applicant at paragraph 21 and the submission that the evidence of rehabilitation is overwhelming. Then she says there is no right at paragraph 22. It is no right to admission to the bar. It is for the applicant to satisfy and discharge the burden of the test of character. So that's the second time that she refers to the test of character. I accept that. But then the court has to balance previous misconduct as opposed to the evidence of rehabilitation. We respectfully submit that if the finding is one of full rehabilitation, then the person is of present good character. And then at the end of paragraph 27, while rehabilitation is important, a show of rehabilitation, the face to pass, may be impossible to make. Well, it may be difficult to make, it's not impossible, and that's, again, an issue of fact. Has the person shown that they are rehabilitated? And then we accept that just saying it would be very harsh if I wasn't admitted after all my efforts is not the test. And then one sees Gossage, where the Americans, in our respect for submission, get it right in the sense that they say that the heavier the crime is, the greater the burden to show you're totally reformed. And it may be difficult to show that. But in the end, the American cases correctly say that the ultimate question is, what is your present moral character? And so does the South African case. And that's what the statute says in our respectful submission. And one then sees that at paragraph 31, she says, to give the orders which he and others gave to liquidate them, and in circumstances in which they were given, position away from the actual scene itself portrays a lack of moral judgment. We accept that on that finding, at the time, 35 years ago, it did show a lack of moral judgment. The question is, what's the position now? And then the onerous burden on it to show his suitability is commensurate with the gravity of the crime. Again, we accept that. Crime of murder is the most serious known to the criminal law, may attract the harshest penalty. Then there's an example of how the US declined admission, but it wasn't because of perceptions, it was because he hadn't shown that he was fully rehabilitated. Apparently successful is the key word. And in Reham, she refers to, claimed to have lived an exemplary life, viewed his admission to the bar as his path to redemption, way to pay a debt of honour. The court in that case found the point of admission is not reward. But if one looks at Ham, what the court found in Ham was he was not fully rehabilitated because he hadn't been paying maintenance to his son. They've said he claims to be fully rehabilitated, but as a matter of fact, we find he hasn't shown that he is fully rehabilitated. But the logical corollary of that, and we respectfully submit the logical corollary in our case, is if you have shown you're fully rehabilitated, you are then, in our respectful submission, a person of good moral character. So that the Ham case is miscited and misapplied in our respect. We'll take the court to it. But it's quite clear that the court in that case was saying, actually, we're not convinced that he's fully rehabilitated, because as a matter of fact, he hasn't paid maintenance, and as a matter of fact, he lied to us and he lied to the board below about why he hadn't paid maintenance. We found his... So again, as my Lord Thumpson's indicated, it's a question of fact, but the question of fact is one which can be determined by he has discharged a very, very high burden on someone convicted of offences of this gravity of showing that he's fully rehabilitated, in which case, in our respectful submission, he becomes a person of present good character.
But the word present doesn't appear in the statute, does it?
No.
It underpins your submissions that
Yes.
good character is a series of snapshots, and we must look at it as at the time of the application to be admitted.
Well, it conforms with the Judeo-Christian idea that the person develops over time, and if at the time that he's before the court he has developed to being a good person, what went before does not reflect. I mean, we might as well get rid of any concept of persons if you say that though the person who did that 35 years ago has changed, and the person before the court is a person of good character and sense of good moral standing, if one says, well, yes, but he did something terrible in the past, therefore he's not a man of good character, we respectfully submit that takes no account of the capacity of the personality for change, which the American authorities stress is a crucial factor, and indeed the South African. And indeed, we say there's nothing inconsistent in any of the cases that have been helpfully drawn to the court's attention. I mean, we cite...
There is not a snapshot, is there? Character is a cumulative quality, reflecting somebody's life. It's not a snapshot. It's not a snapshot. It is the cumulative right to a good name that somebody acquires over his lifetime.
Well, my lord, I understand what your lordship's putting to me, if I can respectfully say that. I respectfully submit that the test is the person now making application a person of good moral character, i.e. his personal qualities are good now, and that the fact of past misdeeds cannot, as it were, doesn't necessarily trump the current good character.
Well, you accept, Mr. Fitzgerald, I think, that making an assessment, a contemporaneous assessment as to whether this individual is of good character, must embrace his past.
Yeah, I accept.
Yes. But your submission is that it cannot be the case that you're inevitably bound to the legacy of your past.
Well, my lord, that is my respectful submission. And that's why then, and that's where the context of the past offence comes in, and that's stressed in all the cases, where judgments have had to be made against the background of offences committed in times of conflict, if I can put it that way.
There's no question of a snapshot. It's a panoramic view of the character, but you say that his rehabilitative process since the commission of these offences allows him to overcome the stigma that the original offences must bring to the assessment of his character.
That is my submission. I mean, I realise that this is a profound, in a sense, philosophical issue. I know it's a legal issue too, but I do respectfully submit that the best guidance to the answer is to be gained. I would respectfully submit, actually, from the American and South African authorities, what Lord Bingham is saying. I know the court's read what we submit, is you've got someone before you who is in Bolton, for example, who is saying it would have a disastrous consequence for my life, my family, if I were disbarred or suspended, because I would cease to earn a living. And he's saying those kind of personal factors about the impact on you are trumped by the need to have a person of good moral character in order to maintain the reputation of the profession. And therefore, we can't sort of say, well, it's very harsh on you, or it will do a lot of damage to you and your family. Those things are trumped by the objective need to have people of full good character practicing the profession. And you've just shown by your recent conduct you're not that person.
And to protect the reputation of the profession.
Yes, I do accept that. I accept that's the rationale and that's the purpose of having a high test. But I don't respectfully accept is that then there's an additional test when you've passed that fully rehabilitated, and it's got to mean fully rehabilitated, and if there are question marks over it, you're not fully rehabilitated. But if you do establish that, I respectfully submit that there is no room for, but it wouldn't look good.
Do you submit that the law of Grenada is different from that of England?
Well, in this respect, my lord, I do, that we don't seem to have that clear formulation in the statute of is the person of good character.
Well, there are statutes, notably those dealing with judicial appointments,
Yes.
which expressly require good character. Wrong, but a serious criminal record would invariably debar somebody from judicial appointment.
Well, my lord, what I respectfully submit is that it's a matter for obviously it's a matter for this court, that there is no authority at the Privy Council level to determine it. But I would respectfully, I am inviting the court to take those words, the test of good character, as referring to present moral standing, because that's what the profession requires, someone who people can rely on and trust. Because if you can't rely on and trust them, that does undermine the reputation of the profession. But if you can rely on them and trust them, and you're quite satisfied of that, then in our respectful submission, that maintains the reputation of the profession. And indeed,
there's a cut-off, isn't there? I'm sorry, I didn't mean to cut you short. There's a cut-off, that you look at the need to protect the reputation of the profession until he's rehabilitated. So that if, for instance, you had a member of the bar who'd been admitted many years ago, but had committed offences of dishonesty, let us say, but had rehabilitated and paid everything back on everything, on your submission, it would not then be open to the authority which was charged with the question of whether he should cease to be a member of the bar to say, well, he's become rehabilitated. So the fact that he was dishonest in the past and that casts very badly on the profession is no longer a matter to be considered. That's effectively what your submission leads to.
my lady, yes, in answering the final question, that is, yes. In other words, it's been trumped by full rehabilitation. I mean, if I can put it that way.
Because there can't be any difference, can there? If somebody would have been disbarred, it would be odd if that same person could still be admitted afresh.
Well, my lady, because this is an issue where, and again, the authorities from the different jurisdictions don't all speak with one voice on this. I know that in, I'm going to forget the name, the one where Sir Anthony Clark
yes,
Jigiofo, he does say there should be the same test. But there are a number of authorities, particularly in America, which say that's not the so can I just...
Can I just make an observation?
Sorry.
That we have to remember when looking at the United States authorities that there are 53 jurisdictions and that the decisions we're looking at are very selective.
Yes,
that's the United States.
And also that this is a culturally sensitive matter in which the professional position in the United States is not necessarily the same as that in other parts of the common law world.
Well, if we're talking about regions and regional influences and spiritual influences, I would have thought that there would be closer assimilations on this respect of, and one sees that reflected in the materials which were not admitted by the Court of Appeal, about the deep spiritual respect for the notion of rehabilitation in Grenada. I mean, that is a fact in our respectful submission. It's a cultural fact. And it does seem to influence the US cases too. I accept that all I'm doing is referring to some of the cases which were referred to below, but we say they are of assistance. But can I then turn, because perhaps, so one sees the Ham case being, and then the test at 39, which the court has to apply, is whether there is a potential risk to the public, or more importantly, whether there will be damage to the profession's reputation. We say, if he's now of good character, there will not be damage to the profession's reputation. It's the rationale, not the test.
Yes, but the word character, as Lady Arden has pointed out, it's got to be read in context. You agree there is somewhere here a need to look at the reputation of the profession and public confidence. And you say there's no independent test about that. You may well be right about that, Mr. Fitzgerald, but it's got to come in somewhere, and surely it is actually rolled up in this context in the notion of character itself. I mean, character for this purpose has a public persona element. It's rather like your image, Mr. Fitzgerald, your profile, Mr. Fitzgerald. There is rolled up in this an element that we must not ignore of reputation, confidence, perception. Would you agree with any of that?
Well, my lord, what I would agree is that the person's reputation is undoubtedly a factor. I mean, I have to accept that. But I do submit that if the person has vindicated by good works over a long period of time a new reputation, I keep using the word, but it trumps the past, particularly 35 years on.
Well, I think your submission results to this, does it not? If on a dispassionate, objective analysis of the current condition of your client's reputation, it is found that he is of good character, that cannot be displaced by speculation about how his reputation would be viewed by the public.
That is my submission, but we actually say he is of good reputation in the community now, but there was a lot of evidence which was not admitted to show that. But I should stick to my task. Can I just take you? So you see Ham again. In Ham, like here, some 30 years had elapsed between the offence. That application was refused, even though he had tried to. It was refused because they found that he hadn't led an exemplary life, and it is important that that's a misunderstanding of what Ham actually decided. But then these crucial passages, had this applicant committed these acts while a practicing attorney, this court has no doubt he would have been disbarred. No doubt about that, because it would be conduct whilst a lawyer, and it would be conduct of such egregious evil that one would say he must be disbarred. Disbarment has occurred for less egregious conduct. We accept that. But then, to allow this applicant to be admitted would send an inconsistent message to me. Now, inconsistent appears to be inconsistent with the approach to disbarment.
Well, it's not really very clear, is it?
No, because there is a reference to messages earlier on. But
at 40.
Yes, but
respect for the rule of law.
Yes. But what we submit is that I mean, one of the problems, my lady, my lord, one of the problems is we actually don't know at the end of it what was the basis on which this was decided, because Court of Appeal thought it was an exercise of discretion. But if one looks there, one can only, well, I say the most reasonable interpretation of that is her saying, because this is so serious that he'd have to be disbarred, it would send an inconsistent message to members of the public if someone who would justify disbarment for this conduct were nonetheless admitted for this conduct. And we say that that ignores the 35 years in between and the evidence of rehabilitation. And we also say that in the end, it's not a test of sending messages. It's a test of, as my lords, my lady had put to me, of is this person of good character. Now, I appreciate that my Lord Sumption put to me, well, what else could she be deciding? Can I just tell you what else she could be deciding? She could have been deciding that he's not a person of good character. She could have been deciding that he's a person of good character now, but it would send an inconsistent message if we admitted someone who we would have disbarred for this conduct if it had been committed yesterday. She could, as the Court of Appeal appear to have interpreted, have been deciding, although he satisfies the test of good character, going back to that first bit, it's a matter of discretion even where the person satisfies the test of eligibility. We don't actually know because she never confronts it. She never says, the test is this person a person of good moral character? I find that he is not a person of good moral character. And we respectfully submit that unless one confronts that issue, one doesn't confront the issue which is the necessary issue here. Has his undoubted rehabilitation and reformation trumped the past 35 years ago? And we respectfully submit that the law does allow for the fact that it could. It makes it a very, very high test, but it allows for that. There's no per se ruling out. I mean, I think Lord Donaldson refers in one of those cases to a case of murder where the person was admitted and says he thinks it was right. So there's no per se, you've committed murder, therefore as the reputation of the bar cannot stand you being admitted. It must therefore depend on the context. And then if we get into context, we say there are special factors about the context. Forget for the moment totally the question of whether the conviction's sound. It occurred in a very special context, without a doubt, of virtual civil war.
Well, the context surely aggravates the position because essentially the whole revolution was a defiance of the rule of law. It would seem to me that if in that context you start killing people, it's an aggravating factor that you are basically dispensing yourself from basic norms of publicly administered law.
My Lord, I think I certainly would accept that in terms of judging the gravity of the crime, but when one's determining what light that past offence throws on your present good character, what again, I'm sorry to keep going on about South Africa, but the South African cases do say, well, if your crime takes place in a war situation, there was an old Boer War case in 1907, we have to recognise that in a war or I'd say civil conflict situation, people act out of character. People do.
He was holding public office at the time.
Well, yes, he was a colonel. He was a colonel. Yes. But the evidence was that, Rita St. Paul's evidence was that there was a group of 10 people who, when Lynn Cornwell said, retake the fort and they must be liquidated, all shouted, Central Committee orders, Central Committee orders. I mean, it's the classic example of people being caught up in a moment of crisis in an appalling decision. But it is slightly different from a campaign of drug trafficking, a campaign of murder, a campaign of criminality. It's in a moment of crisis, they took an appalling decision with appalling consequences.
But he was put under risk, and very often in practice, lawyers are put under in positions of risk and where they could be tempted to do the wrong thing. It's not irrelevant, the circumstances of the offence, insofar as they are accepted and common ground.
No, my lady, I accept it's not irrelevant. The only question then is whether in the intervening 35 years...
Yes, I appreciate that submission. I was just trying to distance myself and just look at the circumstances. They can't be... The very serious nature of the offence has to be confronted.
Oh, well, my lady, I hope I haven't clients sought to
Your submission is that it doesn't amount to an indelible imprint on his character.
No.
It has to be taken into account and must be taken crucially into account. But you say that the rehabilitation which he has undergone can and should act as a counterweight.
Well, my lord, we know, and I know your lordship knows far better than I do, how people have acted in conflict situations. For example, in Northern Ireland, I think it's common knowledge that one of the ministers is someone convicted of the Old Bailey bombings. I mean, we do have to recognise that in conflict situations, people do appalling things, and that may not, 35 years on, reflect their inherent character, or it may, and I agree entirely with my Lady Arden that one has to look very carefully, as it were, as to whether the rehabilitation is complete. But here there was a finding that, in terms of personal qualities, there had been complete rehabilitation.
The basic difference between you and the judge that they did not accept your submission, that rehabilitation can expunge the past.
That's right. Well, can I then take the court to the can I just summarise the grounds and then go to the authority? Would that be the
Yes.
course? So if the court has the grounds, they're set out so I think the court really has the point that first, in dealing with the application, the judge misdirected herself. This is at page.
Where are you reading from?
Page 5 of the case, my lord.
Yes.
Yeah, so first, in dealing with the application, the judge misdirected herself that even where an applicant was subjectively viewed of good character, the test of good character also included an objective element to show that rep would not be damaged. And, we've tried to refine that into there's no additional test if the person has established that they are of good character. And the passages where we respectfully submit the judge applied this additional test to good moral character is at paragraph 20, paragraph 39, paragraph 40, and the final one, paragraph 44, the sending out the inconsistent messages. Secondly, the judge misdirected herself by approaching the issue of good character on the basis that some crimes are so serious it would never be possible for a person who had committed them to show he was of good character. And we've given the court can I just give you the passages? Paragraphs 23 to 28, paragraphs 32 to 36, the approach taken to Wright, the approach taken to the Ham case, which we respectfully submit she misread, and then especially 43 to 44, because effectively she was saying, if the crime is so serious that you would have disbarred if they committed it as a practicing lawyer, then the person should be refused admittance because otherwise you'd be sending out inconsistent messages. And that really does result in you can never be admitted because you would always be disbarred. So it does follow, if our interpretation of 43 to 44 is correct, that she was effectively saying that these crimes are so serious that you can never be admitted, or could never be admitted for them, whatever level of rehabilitation you should show. I mean, even if you won the Victoria Cross, or you just simply couldn't, whatever, or save the lives of people in the humanitarian disaster. That you just simply could not, because the test is, would you be disbarred for this egregious conduct? We mustn't send in inconsistent messages.
Could you tell me what the grounds for disbarral are, relevant grounds, and is it an automatic process or one which requires proceedings before the Supreme Court?
It's proceedings before, yes.
On what grounds?
Misconduct. So,
and that's defined, presumably. That's defined, presumably. I'd like to see the definition.
Yes, my lady, we will find. I'm so sorry we didn't think of that. But thirdly, we say the judge misdirected us the evidence of the appellant's rehabilitation should by law be given little weight. We have, of course, developed these points in the reply. I know the court has seen that. We say that effectively that is the effect of her interpretation, and we've dealt with that at paragraph 36 sorry, I'm so sorry, at paragraph 33 to 35 of the reply, and we say that on a fair reading of paragraphs 25, 27 and 34, in the context of a case such as this, it couldn't mean anything other than that little weight should be awarded to rehabilitation. She misunderstood in our submission Ham and misrepresented it as saying that it's so grave, that the offence is so grave that you couldn't be rehabilitated from it. And fourthly, and perhaps this is a crucial factor, we say in dealing with the application, whatever the true test of good character, the judge failed to make any finding as to whether the appellant was in fact a person of good character or not. And you have our submission. We've developed it.
You've made that point already twice.
I'm so sorry, madam. We've developed that in the reply.
You have.
It's in the reply at paragraph 36.
I think my lord is being benevolent. We've made it perhaps even more than twice. Anyway, we've got it.
I got the point.
I apologise. Sixthly, the judge made, having done so, she fell into error. And then we say also that the judge failed to have regard to highly relevant considerations. Perhaps I can develop that in due course. And also that we do respectfully submit that the Court of Appeal wrongly ruled. We don't have their ruling. It was taken at an earlier hearing in February. But I understand they referred to the Layne-Marshall test. We say it wasn't appropriate to simply say you should have done this before. This was a highly unusual case. It's not as if one can say everybody knows that when you come to a hearing of this sort, you should have marshalled before the court all the evidence that your reputation will not be damaged, that the reputation of the bar will not be damaged. It's simply what happened, and it's quite clear from the chronology and the submissions, is that Mr. Ruggles-Ferguson and his team fought that because the Attorney General was not objecting and because the bar were not objecting, they had established, as it were, that there would be no damage to the reputation. They were saying, look, and it's passive throughout the submissions made, both in writing and orally, look, the Attorney General is not objecting. The bar is not objecting. Therefore, we must have satisfied that test. Now, it may be said now, well, you should have realised that it didn't satisfy the test. But to apply a Layne-Marshall test in a case such as this, in our respectful submission, it is unjust. The test is interests of justice. And it was overwhelmingly in our submission, in the interests of justice, that series of affidavits from the Deputy Commissioner of Police, from the former Prime Minister, from one of the relatives of one of the victims, saying that as far as we're concerned, it would not damage the reputation of the profession if this person was admitted, because in our community, which none of the judges who decided the issue belonged to, they're all from out of Ireland, if I can put it that way. In our community, it would not damage the reputation of the bar. We respectfully submit that that was evidence that was plainly admissible, plainly relevant, and that it was in the interests of justice.
In the interest of justice to admit it.
To admit it.
But isn't the question of damage to the reputation one of law, which the judges have to form a view on? You can't just have a series of affidavits which express it from one individual's point of view.
Well, an opinion poll.
And the second point I just wanted to make is that or an opinion poll. The second point was that really in a situation where in this global world you're having to look more to an international standard of what would be a good character. But obviously it's important that the legal profession holds a high reputation, not just in the island, but elsewhere too.
No, well, my lady, I think I certainly accept the second, but my lady, if it's an issue of fact, is this person of good moral character? And part of what affects that fact is how it would be perceived by the general informed public. Then I respectfully submit that it is relevant how the public would perceive this, because in a sense the court is deciding whether it would damage the reputation of the profession in the context of a particular society. It's got to have regard to what the societal values are and try to assess what they are. And if it's a society in which there is understanding of the special context and there is understanding of the fact of full rehabilitation, we do submit that that is relevant to the issue. Would it damage the reputation of the Grenadan bar? That's my submission. But my lady, I do accept that yes, I see that there is an international dimension, but then of course the international community includes the US, includes South Africa, and there clearly are communities where there's more understanding of the need for reconciliation and moving on.
I suspect
and also
varies in the United States.
Sorry?
I suspect the practice varies.
Oh, absolutely. I mean, some states, your leadership, some states, if you've just smoken a spliff, that's it. But in some states, there's a generous approach. I do accept that,
do I understand your submission to be that given the lack of opposition by the Attorney General and the bar, it was, if not a given, certainly it was assumed that the question of how admission to the legal profession of the appellant would not be a contentious issue, and that really the application to adduce further evidence was stimulated by the terms of the first instance judgment.
That's right. Can I just give you the references? In Mr. Ferguson's written submissions, at page 39, he refers to the fact that there's no opposition to the application. At the hearing, he refers to it 3 times. Page 53 says there's no opposition from the bar and the Attorney General, therefore there's no risk to the public or to damage the reputation of the profession. He deals with it again at page 58, where he says because of the support of his colleagues, you should infer there's no damage to the reputation of the profession. And then he says, in referring to the Shotari case, the Mr. Justice Mitting decision in Shotari, where Mr. Justice Mitting posed the question, I asked myself, is it necessary to protect the reputation of the public, of the profession? And he says, no, because again, there's no opposition. So not unreasonably, in this utterly novel situation, Mr. Ferguson thought that that was sufficient. It turned out not to be. It's not as if there's some established canon. You always, in these cases, get statements from distinguished people about this matter, so that it can be said, well, it was a failure. But in any event, what's the remedy? Sue your lawyer? Or is it admit the evidence and at least look at it? No. We respect, this is one of those cases. We've given you Labrador in the criminal context, overriding interests of justice, not the Layne Marshall test. The E case, which the judicial assistant helpfully drew attention to, itself recognises that Layne Marshall is not the be-all and end-all, and there are cases in human rights context, Fenja Vesi, things like that, where it's recognised that when it comes to human rights, the Land Marshal is not necessarily the only test.
Right.
So, my Lord, so those submissions. Now, can I just then briefly, I think the court actually knows our submissions, but if I could just take you shortly through the cases. Bolton, we've dealt with at page 445 of the, in the bundle, Bolton the Law Society, and we've put our interpretation on that 4.4, because orders made by, so Sir Thomas Binning was there saying, are not primarily punitive, follows the considerations which should ordinarily weigh in mitigation of punishment have less effect on the exercise of this jurisdiction than on the ordinary run of sentences. It often happens that a solicitor appearing before the tribunal can adduce a wealth of glowing tributes from his professional brethren. He can often show that for him and his family the consequences of striking off of suspension will be little short of tragic. Often he will say convincingly he has learned his lesson and will not offend again. On applying for restoration after striking off, all these points may be made. The former solicitor may also be able to point to real efforts made to re-establish himself and redeem his reputation. All these matters are relevant and should be considered, but none of them touches the essential issue, which is the need to maintain among members of the public a well-founded confidence that any solicitor whom they instruct will be a person of unquestionable integrity, probity, and trustworthiness. And then we really, as it were, triple underline the word thus, because what does this principle operate to exclude? It's thus. It can never be an objection to an order of suspension in an appropriate case that the solicitor may be unable to re-establish his practice, i.e. personal hardship. If that proves or appears to be the consequence, it's deeply unfortunate. It does not make suspension the wrong order. So you can't plead hardship or unfortunate consequences, and it's important in our respectful submission that Lord Bingham isn't giving the need to maintain confidence in the profession some unanchored, all-embracing sanction as the criterion. He's explaining why thus certain things are excluded. That's to say hardship and personal misfortune. And then the reputation of the profession is more important than the fortunes of any individual member. So we submit that that's Gidiofo actually just applies Bolton. We do, Gidiofo is in tab 18, my Lord, and we have that. So tab 18, one sees that there is, could I just take you to page 662 at tab 18? We submit that in the passage approved by Sir Anthony Clark, this is being an admission case, at paragraph 15 from Fleischmann, one has exactly the point we respectfully make, which is halfway down the quotation from Fleischmann. The requirement that an applicant for registration be of good character secures the need for the public to be protected by the maintenance of high standards and the high reputation of the profession. So again, it's the rationale or purpose rather than a freestanding, and the test remains a test of good character. And then one does have, at paragraph 17, something which appears to suggest a freestanding test. They were, in my opinion, correct to accept them. The points made on behalf of both appellants were rather that each case must be considered on its own facts. And then I accept the submission that the facts of the individual case are critical. Much depends upon the nature of the wrongdoing, dishonesty or other untoward conduct, and a particular part played in it by the person concerned. This is, I think, especially so in considering whether the reputation of the profession would be damaged by admission or readmission. Thus, offences of dishonesty have been correctly regarded as of the greatest importance. And then the reputation of the profession relies upon the honesty and good faith of its members. Again, that's the purpose. And then, as Sir Thomas Bingham put it in Bolton, the system will almost always be struck off, however strong the mitigation. Moreover, it's in this context he used a striking phrase that the purpose of the strict approach in Bolton is to maintain the reputation of the profession as one in which every member of it, of whatever standing, may be trusted to the ends of the earth. I'm not sure we'd all situations satisfy that test, but in any event, I mean...
Not even you, Mr. Fitzgerald.
No, definitely not me. But all I'm so respectfully submitting is that, of course, it's the justification that the court can trust you, that your clients can trust you, is of crucial importance. That's the rationale again, and the test remains the moral question of, is the person of good nature? And then if one goes on from there, one has we've referred to Bolton and Gideofa. In the reply, we've dealt with the cases helpfully and passages helpfully stressed by the judicial assistant. And can I just take you to our reply? We've dealt with Bolton at pages 5 to 6, Gideofa at page 6 and 7. Patel, that's the decision in the supplementary bundle where they're dealing with the medical profession, and that's where the language of subjective and objective does occur, but it's a particular context. Paragraph 15, so we have it at 961 of the bundle, but what Lord Layne is saying there is that personal mitigation is...
What paragraph are we looking at?
Paragraph 15 of the reply, and if we look at page tab 5 of the supplementary authorities, my
Which paragraph of the decision?
996. If we could look at paragraph 7.
Very well.
Yes, 961, my lord. This was the context of the case before the Professional Conduct Committee. Strong mitigating factors. Council reviewed the mitigating factors, record of achievements, the medical service, as well as a generous man. Those, in our respectful submission, are all objective factors. He either is in the army or he isn't. He either is someone who is exemplary record or generous or not. So nothing subjective about those. And then going on at the end, that he says at paragraph 11, this is the context in which the argument that a direction for erasure was unjust must be considered. Giving careful consideration to all the mitigating factors advanced, the board concludes that the professional conduct was right to subordinate those subjective factors to the objective need to protect the public interest. So that's the nearest one gets to this subjective objective. We gratefully adopt my Lord Sumption's analysis that in fact they're all objective. It's just a question of what period of time and what relevance or what weight they have. That's what we submit in relation to Patel. But we do say that's the only passage where we've been able to find this antithesis between subjective and objective, and it doesn't really support the approach taken by the judge in this case. And then McMahon, supplementary bundle, tab 4, that's where the court asks there's a talk of the reputation of the profession, and at 952 there's the reference to paragraph 19. 952, paragraph 19, in such cases the tribunal's decision should be one that both vindicates the reputation of the profession and protects the public against the risk of repetition. We accept that. The question is, how do you do that? And we submit by applying a high and exacting standard of what we would submit is present good character. And then Shatari, Mr. Justice Knitting, that's at tab 6. He does actually formulate the test, as it were, unmediated of simply, is this person someone whose admission would damage the reputation of the profession? And what we can see that page 969, paragraph 18, if I stand back now in the light of the material before the tribunal, before this court, and ask the question, is it necessary for the protection of the public that this appellant should have her name removed? I answer, notwithstanding the deplorable disciplinary, it's not. And if I ask, is it necessary for the protection of the reputation of the solicitor's profession. My answer likewise, albeit not without hesitation, is it should not. And then it was fine how...
Well, I think you quoted this in your case.
Yes, yes. Well, we quoted in our reply. Yes.
Reply, yeah.
Yes. So then that really leaves the American cases, if I can take the court to those. The American cases are, we summarise in our case at page 449, and they are threefold. That Manville was, which is at tab 13 of the bundle of authorities from page 608 onwards. We've quoted the key passages we rely on. Manville at 612, where it says, yes, can I just, perhaps I could take it from page 611 at the bottom. We do not, as we will explain, I'm so sorry, the page 611 at the bottom, we do not, as we will explain, adopt the position that conviction of homicide per se requires denial of Manville's application. Indeed, no jurisdiction has adopted a policy of per se exclusion in such cases, so far as the briefs of the parties in our review of the case law reveal. Well, that's the case too in England, because we know Lord Donaldson refers to a case where a person was admitted despite murder. We merely recognise and agree with the suggestion of the committee that applicant Manville has much to overcome in order to prevail by a preponderance of the evidence. Because we have not been called upon previously to examine the relevance of a previous felony conviction to the inquiry into moral character, I think it worthwhile to review the matter and set forth some of the principles we consider significant. Courts generally reject a rigid rule that evidence of criminal convictions conclusively evinces an applicant's lack of good moral character. They do so because the ultimate determination to be made is whether at present an applicant has the good moral character required for admission to the bar. That the absence of good moral character in the past is secondary to the existence of good moral character in the present is a cardinal principle in considering applications for original admission to the bar. We do respectfully adopt that. And then one sees, there's a reference, the only US Supreme Court case, we have it here, is the Schwa case, but that was where it was conviction of, as it were, un-American activities or communist activities. And one sees that the Supreme Court interfered and overruled the state courts. One sees at the bottom, the Supreme Court weighed the evidence of Schwa's past improprieties against a showing of good moral character and reversed. Court noted many factors that mitigated his past acts of misconduct, and then they refer to his good deeds. Then the Supreme Court concluded that Schwa was morally fit to practice, ruled the state of New had impermissibly denied him the opportunity to qualify for such practice, and then they lay down all the relevant factors, which we accept are all relevant. And one sees at the bottom of page 613, from a profession charged with such responsibilities, there must be exactly those qualities of truth-speaking, high sense of honour, of granite discretion, strictest observance of judiciary responsibility, fiduciary responsibility, that have throughout the centuries been compendiously described as moral character. And then over the page 614, in view of what we have said, we will remand Manville's application, the record herein, to the Committee of Admissions for further proceedings consistent with this opinion, including investigation. I think it was because the committee had been split 3-3, and so so that's Manville. And then if we just the same theme and the explanation with respect that the judge didn't get it right about Ham, in the matter of Ham, it's tab 17, and the board has that. Under the rule applicable, that we've quoted the key passage.
What's the electronic number, please?
Oh, it's page 646 onwards.
Thank you.
646, yes. So that's Ham. And we've quoted the key passage about present moral character at page 450 of the case.
Yes.
But if I can just show the board at page 649, one has, yes, the key passage at the bottom of page 649, paragraph 17, we also agree with Ham that under the rule applicable, our concern must be with the applicant's present moral character. in Greenberg, we explained that it is the applicant's moral character as of now of which we are concerned. Past misconduct is not irrelevant. Rather, this court must determine what past bad acts reveal about an applicant's current character. And then, again, at paragraph 21, page 650, his past criminal conduct affects the burden he must meet to establish good character, but it's not conclusive. The prior conviction is not conclusive of lack of present good moral character. And then just if we look at, so it's not correct as the judge interpreted Ham that this was a case where they found, despite his complete rehabilitation, his offences were so serious. If we look at the bottom of page 651, we share the committee's deep concern about Ham's long-standing failure to fulfil or even address his child support obligation to his son. And then they say, Ham advanced several explanations for his failure to do so. Like the committee, we find none of his explanations credible. And then if we go down to the... So they were finding he hadn't been fully rehabilitated, not that despite full rehabilitation, his original crime trumped that. Para 31, behaviour of such long duration cannot be considered as a temporary aberration. So you're looking at has the person led a life of crime over a sustained and lengthy period of time, which might be an indication of an ingrained defect of character. And they say, we also agree with the committee that Ham did not display honesty and candour in discussing his failure to testify, etc. And then at page 654 at the bottom, because James Ham has failed to meet his burden of proving he is of good moral character, we deny it. So the judge quotes it for a proposition which it is not authority for, and she quotes it twice as it were, comfort in reaching the conclusion that there are some, as it were, crimes which are so grave that you can't, however much you rehabilitate, ever live down the past. On the contrary, Ham establishes that the key test is present good character and simply finds that on the facts he hadn't proved that. Sorry, sir. Yes. My learning from Mr. Ferguson draws attention to the point at paragraph 31, page 652, the last sentence. His failure to meet his parental obligation for nearly 30 years makes it more difficult to make the required extraordinary showing that he has conducted himself as a man ordinarily would, should, or does. So, I mean, it really was, in our respectful submission, a fundamental misinterpretation of it, though she relies on it twice. Praga is the next case, tab 16, E632, and Praga lays down the test at page 634. He'd previously organised and run a large-scale international drug smuggling operation for over a long period of time. So this was misconduct over a long period of time. The test of moral fitness for instatement is two-pronged. Not only must the petitioner demonstrate the requisite moral qualifications learning law, he must also show his resumption the practice will not be detrimental to the integrity of the bar. The rules govern original admission to the bar, promulgated prior to the development of the rules, have no reference to the integrity of the bar or the public interest. Thus, it is appropriate, despite the lack of specific directives, to consider the public perception of and confidence in the bar when determining the fitness of original applicants. The protection of the bar is universally recognised as a significant and central goal of admitting only qualified persons to the practice of a particular profession. And then
that's quite helpful, isn't it? Because
yeah.
It does. You accept, on the basis of this and otherwise,
yeah.
that perception and confidence are rolled up in what they call fitness and we're calling character.
Yes, my lord, I do. But if one then looks at the context, it seems to be that and I accept that. But what does it, as it were, operate to control? It's the quantum of proof necessary to prevail in a showing of good moral character. Does my lord see although we have not announced, so that's, as it were, what it goes to, and that's really what we say Lord Bingham in Bolton goes to. How strong has the evidence got to be, given the need to maintain confidence? And we have, although we have not enunciated clearly a quantum of proof necessary to prevail in a showing of good moral character, we note that several jurisdictions require a showing of clear and convincing evidence where the applicant has been convicted of a felony. So one sees that. And then one sees over the page the actual application of this. It is premature at this time, given the severity and length of Praga's misbehaviour, to conclude that Praga has shown he is now fully rehabilitated and worthy. So it's a very exacting test, follows from the need to maintain the reputation. But it's very interesting that they're saying, not he can't prove it, given he's had many years as an organiser of an international drug smuggling operation, but he could prove it, but he hasn't yet done it. And then they say at 637 at the bottom, the applicant may be on a course of conduct conducive to a future finding of rehabilitation. We conclude, however, that 7 years of accreditable work history, etc., are insufficient to show good moral character when balanced against approximately 16 years of marijuana use, international smuggling, and living as a fugitive. But that's no, as it were, that approach, which we would commend, is no bar to a positive finding of good present moral character in our case, where there's been 35 years since this appalling decision on the conviction, on the basis of conviction, taken in the special circumstances in which it was taken all those years ago. And so, can I just also, so that's the Chief Justice, Liakos, and then the dissenting judge, Justice O'Connor, we do commend, because he then quotes at page 640 from the Chief Justice McCusick in a case of Jackson in the Bar of Maine. However, the true test of admission to the bar is not whether the applicant has been possessed of good moral character throughout his life, but rather whether he is now possessed of good moral character. I mean, that's perhaps in favour of the where are we now, rather than if it's your life is a kind of a picture where the first part of the picture, I mean a tableau where the first part of the tableau can never be lived down, but rather a progression in which you can pass beyond it. This view is consistent with the importance our judicial system places on the concept of rehabilitation. The court does not perceive that the public interest, which is the paramount consideration here, would be served by never allowing an applicant to adduce proof of his changed character, for to adopt that rule would be to deny any potentiality for reform of character and to discourage individuals from attempting to rehabilitate themselves. The court rejects that a felony bars one absolute regard. Such is not the law of Maine, and then he applies that and dissents. And he talks about the importance of repentance and rehabilitation at page 643. And then at page 643 at the top, second, court rightfully does not wish to send the wrong message to the bar or to the public. Court is very properly concerned about public perception of the integrity. I respectfully suggest, however, this court's order denying Praga's application to the bar delivers the wrong message. A fundamental precept of our system is that men can be rehabilitated. So they both stress the importance of, both judges stress the importance of the now position. The dissenting judge says that he has rehabilitated himself. The Chief Justice says he may well do it eventually, but he has not yet done so, given the shortness of his period of rehabilitation as opposed to the length of his period of criminality. Now, in advocating this approach, we respectfully submit that it does, one, accord with a fundamental value which is ingrained in the penal system of all common law jurisdictions. That's to say that criminals have the capacity for change and to be rehabilitated. It conforms of a Judeo-Christian value which is definitely fundamentally active in Grenada, as shown by the evidence before this court. And in our respectful submission, it conforms with the notion that there is development. I mean, he was 25 at the time. I think the latest, Lord Wilson, the latest psychiatric evidence about brain it carries on developing right until you're about 24, 25, you know. So I don't know what happens after that. But all I'm saying is he's just out of the period where, you know, the brain evidence is showing that you're still changing and developing at 25. We do respectfully submit that therefore, insofar as the judge didn't give a decision at all, she was, in our great respectful submission, avoiding the issue of confronting. Did he in fact, is she really prepared to say he's not now a person of good character? Secondly, she left it with us all arguing about, well, what did she decide? And the Court of Appeal saying it was discretion. It's in our respectful submission, it's open to a number of interpretations. Secondly, we say it was wrong to adopt the test of reputation can be an independent reason for refusing even when you're fully rehabilitated.
Can I just pursue that just a little bit more with one more case?
Yes, my lady.
You're saying reputation isn't a separate requirement, it's the reason for the good character requirement. Yes. And Lord Wilson said to you, well, it has to come into the evaluation somewhere, and I think you were accepting that, but it's in terms of judging what is good character. What in this context do we make of what Lord Donaldson said in the case to which
we've referred?
Mr. Justice Charles.
Yes, well,
it's at 791 in the electronic bundle.
Yeah, my lady, we put it in because it was against us and we thought we'd better draw it to the court's attention. But
it's more comprehensively against you, possibly, than
I can't understand
yet
well
indulged in.
Yeah, no, well, my lady, we've referred to it in our
you did.
submissions.
You did.
Yes, it's at pages 14 to 15, where one has Lord Donaldson, paragraph 29, says, is this the sort of case where even if the back history was known, without the explanation as to what has subsequently happened, a member of the public would say, that does not shape my faith? Well, he is introducing the members of the public, so that if it's right, then members of the public are relevant. But I accept it. I accept, my lady, it appears to be contrary to our submission. We don't really understand, with great respect, what Lord Donaldson, what exactly he was saying.
We don't have the whole report.
No, it's just quoted that we have been trying to get it, but we know. So if we look at it in Strachan, which is at EB 782. So EB 782 that's in the authorities.
Is it 791, isn't it?
791. Yes, the quotation 7. Yes, no, and we do accept that. It's so 791. Yes, Lord Donaldson says. He refers to the fact that there's been some publicity given to a case at paragraph 34, which did not come to me but was decided by the Law Society, in which a gentleman applied to become a solicitor, not a striking off case, in which he had been found guilty of murder. That was a difficult decision. I happen to agree with the Law Society's decision to admit him. So that's clear. But that is the sort of thing which the profession has to agonise over. There was absolutely no doubt that on his own merits he was entitled to become a solicitor. But it was a question of the reputation that caused the Law Society such anguish. And then the paragraph 35 paused to comment that, in my view, this is an example of the flexibility needed to ensure a fair process applied, need to have regard to all relevant considerations, serious offence. And then he cites a further passage from Lord Donaldson in that case. Can I just take you, I think it's halfway down the quote at 792. What I do say, and say it with emphasis, is this acceptance by the public of the total and unquestionable honesty of members of both branches of the press is something which is totally fundamental for the continuing welfare of both branches. It's not something which has to be tested by evidence. The tribunal seemed to think we have got to find that some member of the profession would be shocked or surprised solely on the ground of loss of public confidence. Said it was difficult to form a view the reputation of the profession would suffer. And then, so this is really my Lord Assumption's point about you don't need evidence. But one sees at the bottom, what logically they had to ask themselves was, is this the sort of case where, even if the back history was known, and without the explanation as to what has happened subsequently, members of the public would say that does not shake my faith in solicitors. I just don't quite understand what Lord...
You mean his exclusion of the explanation as to what has happened subsequently? Yes. You're puzzled by that?
Yes, puzzled.
Isn't he saying that we, the Law Society, know the attempts he's made at rehabilitation and the good things he's done, but members of the public generally wouldn't necessarily? That was how I read it, but maybe I'm wrong, because we don't have the information.
But I would respectfully submit that it must be, if the test is going to be how would the public react, it must be well-informed members of the public who know the whole history.
Why?
Because you can't simply say, as he said, I mean, otherwise you just say, well, he's convicted of murder, that's it.
Well, I think the answer is if it's an objective assessment of good character, it must be on a well-informed basis.
Yes.
It can't be other than.
Well, that would be my respect for it. And moreover, Lord Donaldson approving of the person who was admitted despite previous conviction murder, if it was simply how would the public feel about the idea someone convicted of murder was called solicitors, they would be, I guess they would be disturbed, then one would be going contrary to all the authorities which say you have to look at the context, the nature of the offending, the scale of the redemption since, you have to look at all those factors. But if you just simply say murder, that's it. It's contrary to all, well, there's all those American cases, not per se, but even Lord Donaldson seems to be saying that there. So that's my respectful answer. That I appreciate the point that, an uninformed member of the public might say, well, I don't like the idea of murderers being in the profession, but that clearly cannot be what Lord Donaldson's saying, given that he's approving of the admission of someone who had been convicted of murder, but I'm saying I happen to think that their decision was right. So we say you do have to look at the full history, and indeed I think Mr. Justice Charles said that you do have to look at the back history.
Now, Mr. Fitzgerald, before you finish, I think you wanted to refer briefly to some South African.
Yes. My Lord, we have. So the South African cases are. It's Slabbert and Boone. Yes, Slabbert and Boone, there's an article, and then while we're at it, KwaZulu-Natal Law Society and Ex parte Kraus. So the article really summarises the position very helpfully in about 3 pages. And there was a Mandela case, but where he was disqualified. But we haven't managed to.
Well, since you're all doing this pro bono, we can't criticise you for not having given us this stuff beforehand.
Well, my Lord, what happened was we understood that the court wanted some assistance on CCJ, and then we cast the net as wide as we could.
Yes, very well.
Yesterday. So the court can see at page 1503, this is in this article by Slabbert and Boone, that's quite a helpful summary. The fit and proper person requirement is interpreted by the courts. It goes without saying the criminal record is a material fact in an application for admission to the legal profession. That's 1503, and that an applicant who has a criminal record must disclose the fact regardless of the nature of the offence. In Kaplan, the court held that the fit and proper person relates to the personal qualities of the applicant. In deciding whether or not the applicant meets this requirement, the court must consider whether he or she is a fit and proper person in relation to such matters as the prestige, status and dignity of the profession, integrity standards of the profession and responsibility of practice. This case involved a readmission application by an attorney who had been struck off the roll for unprofessional conduct. And then he's also subsequently convicted of perjury, theft, fraud, and the contravention of section 33(1). And then they deal with the question is, the question whether it could be with complete confidence accepted the applicant is a fit and proper person to be readmitted. The applicant in this case was refused readmission since there was insufficient evidence before the court. The applicant had undergone a complete and permanent reformation. Again, the underlying thing, if he has, that's enough. In Ex parte Kraus, the applicant had a criminal conviction for attempting to incite murder. That's the 1907 case. It arose out of the Boer conflict. And basically, the person who was inciting murder against someone who had advocated that, as it were, the rebels in the conflict should be shot on sight. So there was an incitement to murder him, and the South African court found, contrary to the Inns of Court here, that you had to understand the context. The court held that it is not the mere fact of a criminal conviction which disqualifies an applicant from being, but that in the majority of cases the conviction exposes the applicant's character as being unworthy of joining the ranks of an honourable profession. The court found that the crime in this case was political in nature. It's actually a bit more subtle than that, and not motivated by any desire of personal gain or revenge. The crime therefore did not reflect adversely on the applicant's character. His application was successful. The character approach was applied in a number of cases up until 1956. However, in Matthews, the court rejected the character approach, instead adopted the duty approach. According to this approach, the question is not whether the criminal conviction reflects adversely on the applicant's character, whether it is consistent with the duty of legal practitioners to uphold the law. In Kazu, the applicant had 2 previous convictions of contravening the Suppression of Communism Act. It was argued on behalf of the applicant. The matter was very like the case of Mandela, in which the character test had also been applied. However, the court declined to follow the Mandela case, holding the approach in that case was too narrow. And then, can I just take, perhaps the board could read for itself, but just at the end, this case seems to highlight the important difference between, on the one hand, a practicing attorney who contravenes the law while he's practicing, and on the other hand, someone who contravenes the law and then subsequently applies for admission as an attorney. In the former case, it would seem the legal profession is brought into disrepute, while this is not necessary in the position in the latter case. And obviously we pray that in aid. In Ex parte Mozambique, courts once again declined to follow the character approach. And then it would have rendered it...
He became Chief Justice.
I'm sorry?
Sorry, he subsequently became Deputy Chief Justice of the Constitutional Court.
Oh, right, I'm grateful.
But this was in the period, the apartheid, his conviction was in the apartheid period.
Yes. But I'm not seeking to draw an analogy with the apartheid period or indeed the Boer period, but the recognition that context is all is, in our respectful submission, important. And the Kraus case does, although it's very old and rather unusual, have some observations about what happens in war, which we respectfully adopt. One sees the head note, it's incitement to murder, and then released on parole. Convicted in England of attempt to solicit the commitment of crime of murder. He's not admitted by the bar here, but he seeks admission there, and the finding of Chief Justice Innes is, if one looks at page 225, can I just take you down to nearly the bottom of the full paragraph there? If this incitement had been given out of private spite or to further the petitioner's own ends or to advance his interests in any way, I should not have listened to any argument which said that it did not reflect upon his moral character. The view which I take is the motive of which the letters were written was a political one. Dr. Kraus keenly felt for the success of the cause for which he had fought, defence of which he had been taken prisoner. He thought that the policy advocated by Mr. Forster, I think his policy was shoot on sight, was a danger to the success of that cause. And then perhaps I could just quote this at page 227, first full paragraph. We must consider the atmosphere in which and the circumstances under which this advice was given. Much has been written and spoken in praise of war, but there is this to be said against war, amongst other things, that it blunts the moral sense, tends to rub out the minds even of the best of men, the line between right and wrong which honourable men always attempt to observe. Requires a man of the strongest character to keep his actions during a time of war on exactly the same high moral plane that he endeavours to maintain at a time of peace. I think is a matter of common knowledge. We must not lose sight of that. And and then essentially, for that reason, he holds that it doesn't reflect his present moral qualities. And Mr. Justice Solomon, to like effect, at page 231, just before the end of the paragraph, naturally the applicant would resent Mr. Forster advocating the policy the Republican forces should be treated as robbers and bandits and shot down in cold blood. And it was under the pressure of feelings of that nature these letters were written, upon which he was convicted of attempting to incite murder. And then he says at the bottom, they remove the crime of which he was convicted out of the category of crimes committed from sordid motives onto a different platform altogether. Rightly or wrongly, he believed he was doing in the interest. I'm not prepared to consider the matter of whether this is a crime of a political character. That is an expression of such a vague nature, I do not think I shall be assisted in my conclusion by entering a discussion of whether this is a crime. It was in any case a crime which arose directly out of the war, a crime committed in the interest of the countrymen, because he honestly believed he was thereby furthering their cause. And then at the page, Mr. Justice Mason's judgment, page 233 at the bottom. But of course, this act was committed under very strong political feeling. If we examine the history, we find incidents similar to the present case. I need only cite one case where a man living in another country, I think this is Duke Dengheim, was kidnapped by order of Napoleon, tried by court-martial and shot. The whole civilized world has always regarded that as murder, but it was a political murder. It was never regarded in the same light as if he'd been murdered under ordinary circumstances for private revenge or for personal gain. In almost every country, instances will be found of men under the influence of strong political excitement committing acts which are really dishonourable. Speaking generally, the whole civilized world condemns those acts. But in a single act of that kind sufficient to justify the court in saying that an individual who has been guilty of such an act is of such personal unfitness that he cannot be trusted, that he cannot be expected to act honourably. Oh, my lords, my ladies, I do respectfully submit that a modified version of that sentiment, and I would respectfully submit wisdom, it is relevant, because one can say, what was the context and situation? It was one of effectively civil war. That in that context, this appalling order was said to have been given, with the appalling consequences, which were undoubtedly appalling, of the giving of it. But does that really matter of minutes of in which the decision was taken forever after debar Mr. Layne from being considered a person of good character for the purposes of admission to the bar? And we submit that there the context is of some real importance. And we've provided you with the KwaZulu and Veronica Singh case. I can just perhaps give you the references. It's the same approach about the emphasis is on now at paragraphs 21 to 24 of that case. But so drawing it all together, we respectfully submit that the errors of law which we've sought to identify, no ruling the wrong test of this additional extra factor, even if you're of good moral character, no clarity in the decision as to what she was finding, and then the confusion, if it would justify disbarment, it'd be sending an inconsistent message not to find that it justified refusal of admission, and the effective citation of Ham and cases of that sort of saying effectively you can't trump the original offence by rehabilitation in certain circumstances. All those we say were errors of law. We also say that the judge, who had before her the Bell judgment and had before her the arguments of my learned friend Mr. Ferguson, who was submitting to the judge, and I can give you the references, he was submitting that this was in a special context, and I'm so sorry, can I just find the references to give you? Yes, he was submitting this was in a special context at page 50, at page 54 and at page 75 to 77, where he was saying you have to look at the situation. It was effectively a war, or a civil war. In the judgment of Mr. Justice Bell, which was before the court, there was a reference at paragraph 30, just for one example. Paragraph 30, he says that attention had been drawn to sentencing in cases involving the war in Yugoslavia, paragraph 30, and the need to consider those special contexts in order to promote reconciliation. And then one sees also that at paragraph, this is quite significant, that he records the DPP accepting that the order to retake the fort may have been justified. And we submit that that is relevant. So sorry. Yes, it's. I'm so sorry. It's.
Page.
Yes, I'm so sorry. I'm just trying to find it out. I've lost the place momentarily. But he refers to yes, yes. The order to take the fort being justified.
Bell's judgment, 737. Which paragraph?
Yes, I'm just trying to find the way he refers to the mitigation and then to the DPP accepting certain things, the DPP's situation.
Mitigation.
Ah, yes, here we go. It's page 145. Yes. Sorry, paragraph 145, page 759. Concessions re-mitigating factors. In this regard, the observation must be made, DPP made a number of concessions. These were, one, that there was a violent confrontation, soldiers on both sides were killed. The captain leading the forces to retake Fort Rupert was shot and others were shot. So, I mean, that's the forces of the anti-bishop, if I can call them forces, accepted it may well be that the fort had to be recaptured. That's because it was where all the guns were. Force was necessary for the recapture, accepted that shots may have come from the armed civilians on the fort. That's Fort Rupert, where the bishop faction, as it were, had taken occupation. He did not dispute the events took place within a short time frame, though he said if Fabian Gabriel is to believe there was an hour lull, he accepted the remains of the deceased may have been removed by what he called the Yankee forces, and that there was some mitigation in the background context because of the seizure of the fort by bishop supporters and the fact that it was an army headquarters. So the DPP, who certainly did not mince his words in condemning this crime, made those important background concessions. And we do respectfully submit that that is relevant material, bearing in mind the kind of approach recommended in the case of Krauser, and indeed in other situations of conflict, to whether actions taken in a short period of time in a conflict situation 35 years later really throw light on the moral incapacity of the person who committed them. And we do say the judge doesn't deal with that. She doesn't confront that. There's no word about the context in her finding. Much of her findings reproduce points made by the amicus. There's nothing wrong with that. But she doesn't, in our respectful submission, address that question of context. And again, Mr. Justice Charles, in his judgment, whatever the rights and wrongs of him criticising the process by which conviction was reached, rightly, in our respectful submission, stress the context. All the cases say you've got to look at the context of the offence. You've got to look at the actual facts and the circumstances. And this judge nowhere refers to that point. We've set out the things that we respectfully submit she should have had regard to at 14.2 at page 475. She didn't refer to the fact that offences occurred in a very special situation of civil uprising. The doubts as to the trial and appeal process conforming of internationally recognised principles of due process, I accept that that is debatable in the light of the points that have been put to me by my lords. Thirdly, the fact that in sentencing the applicant he had recognised the difficulty of establishing the exact facts. Fourthly, the fact of expiation in full by serving the sentence. And then the unanimous finding that he was fully rehabilitated and now of excellent character. Those points really don't find reference, nor does the lack of opposition by the bar, nor does the question of public acceptability in the particular circumstance of this case. So those my lords, my ladies, those are my submissions on all those points. The final point, ground 8, I think I've really anticipated its. I say that these statements are relevant. I accept that the court may or may not accept that, but I say that the question of the impact on the public, the reputation, and all things is dealt with. Can I just indicate that it's Madonna Harford for the Grenada Trades Unions, John Doggett, the priest who'd known him all his life, saying there'd be no negative fallout, Adonis Francis, the former police deputy commissioner, who is himself a victim of the revolution, but whose life was saved by you at Layne. A paragraph 14 saying that it's well known that, many people think the trial was not fair. Sir Nicholas Braithwaite, the former Prime Minister, Tilman Thomas, another victim of the revolution, Claude Douglas, the social scientist, and Marcel Belmar, who was herself the sister of one of the victims. If Lord Donaldson is right, that one can look at the public reaction, and in our respectful submission, and if the judge is right that one can say, what is the effect of this on the reputation of the bar? The reputation of the bar doesn't exist in a vacuum. It has to be the reputation of the bar in the community we're talking about, in the circumstances we're talking about. And we respectfully submit that that incredibly impressive body of evidence from victims, from priests, from former police commissioners, prime ministers, trade union leaders, does give some idea that it's not straightforward in this case. We do respectfully submit that that fits in with the fact that there was a special context. So then my lord, then the question is lad and marshal or not, and we respectfully submit Benedetto it's in the criminal context, but where very important human rights or issues of profound civil liberties are at stake, it cannot be right to say, well, your lawyer should have got it right first time, so we're not going to let this in. Particularly where there is no, as it were, established rubric about what you should do in a situation like this, and where quite understandably Mr. Ruggles-Ferguson thought that, as it were, they were home, if I can put it in that rather...
well, I think we've been down that road already.
Sorry.
That's all right. That's okay.
Can I just revert? You just mentioned if Lord Donaldson was right about reputation, your fundamental legal point. You've been relying on an interpretation of Sir Thomas Bingham, as he was at that point, in the Bolton case.
Yes.
But could I just invite you to look at what comes before the passages?
Yes, of course.
It's on 567 of the electronic version. At the bottom of 567 at H, he says, before returning to the facts of the case, he's going to say something in more general terms about the principles of which underlie cases such as this. Then he says, the correct approach to questions of this kind has been laid down in a number of authorities, in particular a number of unreported decisions of Lord Donaldson. And then he says, nothing very surprising about them, but I'm going to attempt to summarise them.
Yes.
And that's what is, I think, I haven't had a chance to read it properly, but I think that's what comes before the passage to which you've taken us. and you say is different from Lord Donaldson.
Yeah. We have now got it. Well, could I try blind and then have a look at it?
Yes.
Okay. One thing we do know, because we've got that part of Lord Donaldson's text, is that he said that murder is not necessarily a bar, because we've got him actually approving.
Yes, I'm not really talking about the specifics. I'm trying to look at the legal principle.
No, I understand. Well, my lady, what we respectfully submit is that Lord Bingham's extraction of the principles from Lord Donaldson is the correct one, which is when you're punishing someone, and because these are punishing cases that he's looking at here, for an infraction, the important thing is to maintain the reputation of the profession by punishing severely, either by suspension or disbarment, those who have shown themselves not to be people of integrity, probity, and trustworthiness in his words. So what he's saying is, and that's why we place great attention on the word thus in the passage, you disregard individual mitigation in the form of hardship. You emphasize the importance of punishing misconduct in the profession in order to maintain standards of the profession. And we have no problem, my lady, with that it's an important rationale and purpose that you maintain standards in the profession. Therefore, when you're considering how to deal with conduct by someone in the profession who has misbehaved, the purpose, it's at 518G, the purpose is achieved for a limited period by order of suspension, purpose is achieved for a longer period by an order of striking off. The second purpose, most fundamental of all, to maintain the reputation of the profession, is one in which every member may be trusted to the ends of the earth. To maintain this reputation is often necessary that those guilty of serious lapses are not only expelled but denied readmission. I mean, again, the context is, what do you do to those who, having been admitted to the profession, as it were, breach their duty to the profession? And we do respectfully submit that in order to maintain the reputation of the profession, you deal with them severely. But to some extent, that can't answer our question here, which is, are you admitted 35 years on for conduct you did when you weren't a member of the profession? But so we say it's clear that Lord Donaldson there was dealing mainly with the proper approach to punishment, and in determining the quantum of punishment for misconduct as a solicitor professional, the maintenance of the reputation of the profession is important, and so that they should be struck off if they've shown that they can't be trusted. But
right.
It's rather like the army, isn't it? I mean, it's. You maintain the reputation of the army by discharging someone who in their conduct as a soldier has brought the army into disrepute. But
there might be some imperfections in that analogy.
Sorry. Okay, my lord, I'm sure there's lots of. I'm very good. Sorry, is that? Oh, that's. Well, unless I can assist the board in any other way.
Thank you very much, Mr. Nesbitt. Thank you very much indeed.
My lords, there are various other things, but they're probably not necessary. But if you wanted the Schwer Supreme Court decision, which is referred to in the cases, it's available.
We'd welcome sight of that if you can produce it.
Yeah, it's here.
Yeah, oh, right, good.
Oh, I see it's been posted on. We'll just pass it on, yes.
Right.
And I think really the rest of it, the learned article that's referred to, the Yale Law Journal article,
yes.
We've got that. It's referred to if the court wants it.
Well, I think we welcome anything that will throw light on the subject, but you needn't distribute it now.
Oh, okay, fine. my Lord, I'm very grateful. My Lords, my Lady, I'm very grateful. And,
Thank you very much indeed. And thank you once again, Mr. Fitzgerald, for enlightening us in so many ways. The Board will take time to consider what advice they will humbly tender to Her Majesty. The Court is now adjourned.